Hi, everybody. Thanks for being here today for our third webinar for choosing the right executor, attorney and agent, plus how we do the settlement process. Like to welcome Matt Trotta from Field Law here today. We work pretty closely with Matt, and we appreciate you being here today, Matt.
Hey, thanks for having me.
Awesome. And thanks, everybody, for also taking the time out to attend.
So one of the key questions that comes up a lot when we're doing estate planning is what exactly is an executor's role in this? And a lot of it is getting over the idea that this has to be a loved one, has to be your spouse, has to be your kids, it has to be all of your kids. A lot of people come in with the idea that being an executor is an honor that's to be just bestowed on somebody who it means a lot to you in your life, but in many ways, doing the estate administration is really like handing somebody the scarlet letter. What they're intended to do is they are appointed in your will to administer your estate, to follow all the terms and to do all the tasks that are required to finish an administration of an estate. This can be everything from locating the will, locating the real will. So in a lot of cases, what happens is people may not leave an organized estate behind. They may make a lot of different versions of their will during their lives, and it's important to find out which one is the proper last will that adequately and properly displays the last wishes. Sometimes this may involve an application for a formal proof of will if there's questions of whether or not the last will is valid, it was done with capacity, and it was done without any undue influence. This will also involve what we call marshalling of assets, ascertaining which assets fall into the residue of the estate, which assets are meant to be specifically gifted, and which assets are used to pay debts and taxes of the estate. The executor will often make funeral arrangements if they haven't been made during your life. Sometimes the spouse will do this with the executor if the spouse is not the executor, but it may vary. Often the default is it's the executor's job. The executor's role will also be to retain professionals, whether that's lawyers, accountants, advisors, realtors, evaluators, and we'll get into more about where the professionals get involved later in the presentation. Their job is also to deal with taxes, debts, and obligations of the estate, making sure all the returns are filed correctly, and to make sure that they have gotten clearance from CRA that there's no taxes owing. This is one that's often overlooked and often can be a very large problem for an unprepared executor because tax liability sticks with the executor if they move any assets out of the estate at any time without paying off CRA first. So this is something that the executor needs to be very aware of and to make sure that everything's filed in a timely manner and to make sure that the returns have been dealt with properly. From there, their job would be to distribute assets of the estate, to get any releases and to deal with any interim distributions with beneficiaries, as well as if there are trusts in the estate, they may very well be appointed the trustee of those trusts. And so their job would be to administer those trusts for the duration that's prescribed in the will, or if there's a special trustee under the will, somebody else other than the executor, their job was to ensure delivery of the trust corpus to that new trustee. The most important part of any estate plan is going to be determining who this person is because of all the roles that they have and all the places where these roles can go sideways. Significant care should be taken in the appointment of executors. It's also very important that it's an introspective examination. Executor advisors and lawyers can assist in helping you ascertain who the right person is, but at the end of the day, we don't know your family and your friends and your network as well as you do. So sometimes it involves some very introspective and very hard questions. Sometimes your children are not the best options. Sometimes your siblings are absolutely not the best option. Sometimes it may not be even your spouse is the best idea, depending on your own personal situation. And this should be something that takes up a significant amount of your discussion with a proper estate planner. Because no matter how good our plans are, if we have somebody in place who isn't qualified, isn't capable, or simply doesn't agree with the plan, it can be partially or totally undone by them. And some of the issues with an executor are as follows. Often they're too young. This is often a case when people appoint their children. You have a situation where they lack the life experience, education, or temperament to be able to handle the death of their parents. It's usually, if they're young, it's untimely. So they're dealing with a mental and personal issue, as well as the issue of administration. The other extreme on that is that they're too old. This often happens where we have clients who are seeking to leave trusts for their grandchildren, or have older or younger children themselves. They'll appoint siblings or friends or colleagues around the same age. What often happens is the executor appointees either pass away first, if the person doesn't change their will before they pass away, or what happens is we have administration of estates and trusts that outlast either the life of these appointees, or outlast the appointee's ability and intention to act or to continue to act. So this can often become an issue if somebody wants to get off of a trust or an estate because they've gotten a bad diagnosis or don't want to be involved anymore. The third major issue is that executors who are appointed have insufficient knowledge, experience, or temperament relative to the estate size and complexity. Now, it's important to note that an executor doesn't necessarily have to have an MBA and a law degree and an accounting degree, or be able to have a degree in psychology to be able to administer an estate. When we talk about experience, knowledge, and temperament, it's the ability for them to be able to handle information, to be able to handle documentation, and to be able to work closely with professionals along the way, to be able to take advice, weigh it, and to make proper decisions. There are certain vocations that are more prone to being successful in this role, but it's certainly not always the case. I've seen estates where a lawyer has acted as executor and they've done a lousy job because they just didn't have the right experience, knowledge, and temperament to do the job.
And Matt, do you find that, when we come across some of the younger people, or even some people that fight with their sisters and siblings and brothers and other family members, I know in the past that's certainly gotten in the way. Is that something that you would definitely tack into temperament and how they can deal with things without being full on scrapping with everybody?
Oh, absolutely. I think that's a really important consideration. When you're appointing somebody, it's somebody who should be able to work well with the beneficiaries and to be able to understand and appreciate what the beneficiary's end goal is, because at the end of the day, they have a duty to these people. We want to avoid appointees who see themselves as a surrogate parent, or see themselves as a lord and master of what is under their control. That is antiquated thinking. It doesn't work in practice, and it's a reason for a lot of litigation that I've seen and am currently involved in.
Okay.
So
Thanks.
from there, we get you're welcome, Tam. We have a lot of situations where executors don't live in the jurisdiction, and the question is that a problem? And often it is, and sometimes it isn't. So it really depends on the situation. But foreign executors, even if they're outside of the province of Alberta but within Canada, are considered foreign, and they have a requirement to post bond or assurance, essentially, for the value of the estate, less than the amount that a court says they don't need to. This is often waived. I've never, in my experience, had to actually have an executor post bond, but what this requires is all of the beneficiaries to sign off, and this may be the public trustee if the beneficiaries are under the age of majority, to say that they understand that the executor is outside and that they'll allow them to go without a bond, and the court would accept that. If somebody's going to cause problems with your estate, one of the first places they'll act is to say that they disagree with the executor, especially if it's a situation like this.
And so how about if you have family in South Africa, or you have family in the United States that you really want them to actually settle and take all your assets back off Canada's, country, basically, to their country? What, I know that's quite expensive over time. And how do you feel about that? Or, what does bonds actually look like, so that people can understand the cost of that?
So that's a good question. How it often would work is, if you have a foreign executor, they need to be physically present to do certain tasks. And so there's going to be a cost of travel every time, and that's going to be substantial. If they have to post bond because a beneficiary won't sign off, or the public trustee won't sign off, or there's some sort of issue where there's a question of whether or not there would be easy recourse in the other jurisdiction or conflict of laws, a bond policy can be extremely expensive. We're talking in the tens of thousands of dollars, because you have to remember this is a policy for the value of an estate. So this may be for several $1 million of coverage. So it's something to weigh very carefully. If you have a co-executor within the jurisdiction, there wouldn't be the same bond requirement, but at the same time, expenses would certainly be magnified by people having to fly up multiple times to review the application, to review property transfers, sometimes even to review and inspect the premises. A lot of that really shouldn't be done remotely, and really shouldn't be done by using an agent without oversight. Using agents are fine, but there should always be the ultimate decision making by the executor. The next issue that comes up a lot is a potential or real conflict of interest between one or more beneficiaries. The most common one that we see is where a step parent is appointed or a child is appointed, and there's a step mother or father involved. So there's very clearly a conflict of interest there. As a surviving spouse, there may be an entitlement to the estate, an estate that they're intending to administer. Question, can they do that properly? Answer, most likely no. Another one that's less obvious than the whole blended family situation may be children from different marriages, or stepchildren, or even adopted children, depending on the family makeup. But there could be more subtle ones, such as a sibling of the deceased and their nieces and nephews. They may not get along very well. There may be a history of friction. There may be a business interest involved. If you have a situation where somebody is a shareholder with dad or mom, and they now have to act on these shares in the best interest of the children, those interests may not be aligned with their own. So that's something that should be considered and avoided in every instance where possible. From there, we often see too many cooks in the kitchen by appointing way too many executors. What I always tell people is there's no safety in numbers, and sometimes one of us isn't as dumb as all of us. It's important to bear that in mind, especially if there's multiple children, that you may not need to appoint all of them. In a lot of cases, there's no benefit in having multiple executors except for fulfilling the wishes of the testator. But our job is to educate and help executors to make testators make advised and informed decisions, and to tell you there isn't a whole lot of value in having multiple executors. A lot of the roles that executors like to share amongst themselves are things that can be delegated out to professionals, and it's probably better to have them do that. It's better to have a professional to appraise and catalog property, to do bookkeeping, to work on applications, to consult with financial advisors. Well, have one executor in the room with an advisor is better than having 5 appointed executors dealing with the advisor and maybe not getting along or having different views, when really simplicity may be key. And the last one that comes up, or last 2 that come up a lot, is not appointing an alternate executor. So this happens a lot in situations where people have do-it-yourselves or cheap and easy wills from the corner store law firm that also does shoe shines and commercial or residential real estate and provincial criminal court appearances. They're not going to take the time necessarily or to appreciate these issues as they come up, because it's just not something that comes in mind. They say, okay, we'll appoint somebody. So here's how you're going to give out your estate, and that's that. Here's your $500 document that may or may not be valid at the end of the day. What happens when you don't have an executor appointed is that it defaults to statute. And so you now do not have control of who the executor of your estate is. It will go to the first class of people under the statutory regime that it falls into. So that may be the children you didn't want to act as executors. because of whatever reason. And it would be all of them would have that shared right. So if there was one child you didn't want to have as an executor and another one that you did, you've lost control of that by not appointing alternates. It may go to that sibling or group of siblings that you don't like or you don't think would be competent. So long story short, you lose control. And that can be a real problem. Or conversely, it could create a vacuum if nobody wants to act or there's very few people around to act. The last one is that executors haven't been consulted. So this is a really key thing, is when you appoint someone, you should make sure they want to accept it. And that's for two reasons. Reason number one, they can reject it once the time comes. And we may have a situation where if there aren't enough alternates and you appointed somebody who didn't want to act, now we're in that statutory regime. The other reason is that you don't want to have people in there who don't want to do the job. And it's important to have openness on that. A lot of these issues in appointing executors are things that will come up in the estate planning process with a qualified practitioner.
And I think, like we've said before too, is, make sure that you're talking to someone like you who's an estate planning expert lawyer. Because I think, all too often, like we said in our last presentation, people are getting, they've had a divorce and all of a sudden they get to the divorce lawyer to do it. And we often have seen some really terrible wills from there, or some terrible wills, like you're saying, from, the person who they bought their house off of, and they don't have as much expertise in doing a will. I think that's so important.
Well, yeah, and I think that's very true. And it's the fact is, in this area, a lot of things are changing rapidly. The tax laws change at least once a year. A lot of the ways that we do things change, and it's a lot of things that you may not realize on a first approach, that if somebody is doing a will as a throw-in, may not realize that it should take a few hours to deal with some issues deeply. And there is a cost to that, but there's a benefit to that and a preventative measure to avoid cost in the future.
Exactly.
So what goes wrong with executors? We've gone into who's the wrong kind of executor, but what do they tend to do wrong, or what tends to happen when we haven't thought these through? Well, a lot of times a good executor is somebody who has, a busy profession or a busy practice. And the problem is, the dark side of that is, they're busy with their practice and they're busy with their profession. They don't have time to properly administer an estate. They may decide not to take the appointment at all, or they may take it on because they feel they have a duty to, and they put their professional, family, and other obligations ahead of the estate and potentially create some liability for themselves. The second issue we tend to see is that lack of, like we talked about, that knowledge, temperament, experience, expertise to handle these matters. And again, it's not necessarily that your appointee doesn't have a couple of law degrees and the tax certification hanging in their room. It's that they didn't know to ask, and they didn't know how to issue spot to get the right people involved. This is especially important where there's assets in multiple jurisdictions and one Canadian lawyer, one Canadian accountant doesn't have all the answers. The third issue is that one that we've been talking about throughout this presentation, which is that whole lack of temperament and that whole conflict of interest and that inability to understand your beneficiaries and act in their best interest. And I just kind of sum it up as a lack of respect. And it's especially jarring and especially interesting when you're dealing with estates where you have adult children well in their 30s, on paper better credentialed than the executor, who are being talked down to because they've interpreted the will or they've interpreted the trust in such a way that they feel that they have to protect these beneficiaries from themselves, and they just don't respect them, don't give them information, consider them to be trust fund babies. They're lucky dad's leaving them $10 million so they can do what I say. That's not how an executor is supposed to be. It's a duty to act in the best interest. It's, if you're saying no, it's you have a reason to say no, not born on any other perceptions or fears. And again, conflict amongst family members is a big one that comes up with executors. And part of the role of an executor is being able to be the peacemaker, to be able to mediate and solve problems. And if this is somebody, as Pam pointed out earlier, who's quick to a fight or quick to create issues or has a bone to pick with somebody, that's a problem when the executor is picking sides. And that tends to bring it over to litigation relatively quickly, or even if it doesn't end up in litigation, you now have a situation where families aren't talking to each other anymore once this is done. There's always that potential for personal liability. And so when you have executors who aren't able to understand the nature of their appointment and to seek out advice where they need to, they very easily can make mistakes. And that's a common issue, especially in tax, but it can also happen in other types of decisions that are made in other types of assets. One that comes up a lot more than it should is the executor who feels the need or feels coerced to make an interim distribution to their beneficiaries before it's time. And they haven't figured out what the tax bill is yet. And they haven't figured out all the debts. And they just wanted to make sure that, this person got their check because they kept asking them. Well, they're liable at the end of the day for tax and to creditors if they're moving money that the estate doesn't have. So they need to be very careful about that. The geographic issues of executors is a common issue. We've talked about that a bit already, so I won't get into it too much more. The other issue is the understanding or the lack of understanding that when there are trusts arising out of an estate, they may need to be managed for a considerable period of time. They may not realize that you have to file a tax return every year. They may not realize that there's other compliance, that there's working with investments, and they may leave these things hanging, and that may cause problems in the future. And with a lot of these issues with executors, these can often be solved with approaching professionals early in the process and working with them. So what's the role of the professional? Well, it isn't always to administer the estate unless you've appointed a professional to do that. In a typical estate administration, there are dozens of tasks. Trust companies will tell you hundreds of tasks, but realistically, dozens of tasks that an executor will have to address during the course of administration. And the course of administration is not just simply the process of going to a lawyer, getting them to draft up the grant of probate application, filing it, and receiving your grant. There's a lot more to it and a lot more time than that. So the average administration will probably last somewhere between 12 and 24 months. Depending on the tax situation, the asset situation, the beneficiary situation. If we encounter litigation, if we encounter tax dispute issues, if we encounter issues with other jurisdictions on property, it can go on for years.
And I know a lot of people come to us and they think this is like a week thing, that they just basically get the funeral arranged and get this all done and get this done and out of their hair within, a week or two. And we've often had that discussion, like you said, is that it often can take, multiple months, if not multiple years. And I think that's a real misnomer that everybody has, that this is a quick and dirty kind of thing to get done.
That's absolutely true. And I mean, and there is some exceptions to that. So if you have a situation where the first spouse passes away and everything is jointly held and there's been some planning and consultation with your professional team, that might only be a short period of time to plan for funerals, to deal with all of the IDs and passports and whatnot, and then to transfer all the jointly held assets, or rather to transmit them into the name of the surviving spouse. So in situations like that, you may have a shorter estate, but in the case of the last passed spouse, or where a spouse has property that they own themselves, you're looking at that longer term every time.
Awesome.
Thanks. So it's important to note that executors aren't expected to go it alone. If somebody's appointed on the piece of paper, it's not up to them to do everything under the sun. They don't have to all of a sudden learn how to manage money and learn how to file returns and learn how to deal with court forms. It's expected, and in most good wills, explicitly stated that they can take out expert advice and rely on that expert advice, and to use those professionals and to pay them out of the assets of the estate. In most cases, the professionals that would be needed to administer an estate are funeral directors, family, wealth, and financial advisors.
Such as us.
such as Pam and Kelly and the team at Tower. Absolutely. And it's important to note that it's not just financial and wealth, but the family part is quite key too, because there is an intergenerational wealth transfer that goes beyond simply signing across investments and setting up new accounts. And it's important for that to be bear in mind. And in many estates, we will put right in the four corners of the document that there's an expectation that the beneficiaries seek out this counsel. And the estate may facilitate it, may pay for any professional fees for that, just to make sure it happens, to make sure that we're actually achieving the goals of the document by making sure the beneficiaries are prepared. Lawyers obviously are an important part of the process with the whole grant of probate or administration to deal with any tax planning that needs to be done, conveyance of real estate, to deal with any private or publicly held corporations that the deceased may have left, as well as partnerships or trusts. And of course, litigation, which we hope doesn't come up, but it does. Accountants and bookkeepers.
We work closely with you to do. So I just wanted to make sure that our whole group knows that.
No, absolutely.
We work closely together on that.
Yeah, it's a very important to have a team of experts approach and to work together early so that when there are issues that are starting to materialize, we can get in front of them collectively, because it may involve more than just one member of the team. You may need the accountant to act early, or the lawyer to act early, or the advisor to act early. So it's very important to have that involved team. Trust companies are often involved in estate administration. They may act as an executor, but they may act as an agent to assist in some of the tasks as an executor. Valuators can be very important in a process if we have shares of companies that aren't clearly defined in their value to be able to deal with real estate transfers or anything of that nature. And then, of course, realtors as well. So while it's explicitly stated in a will that, in most good wills anyway, that an executor can hire experts and rely on their advice, there's a difference between relying on advice and expertise and simply handing the keys off. So an executor cannot delegate decision-making authority. They are the personal representative of the deceased. So it's important that they understand that they have this team behind them. The team acts early, but they have a lot of decisions to make sure that the estate works, and a lot of those decisions come early in the process.
Well, it's easier too that I think, the executors kind of also, know some of these advisors, or at least the advisors know your clients really well that passed away. Because I think that's really important in helping settle this. Because I know, many a times we've come across valuators or trust companies that don't know. Excuse me. But I do find that, a lot of the people don't know that, and they kind of, it's hard for them to settle the estate for sure. And I think they're guessing on some of your wishes. So I think to have that professional team that knows your family is important.
This is very true.
And so everyone who got the invitation has a link in the email that actually had a link to our checklist that talks about making arrangements. And the checklist that we follow, of course, there's lots of other things that enter into the equation. But I think what we've tried to do is make it simpler for everybody to kind of go through some of the things that they need to do and what we normally follow. There's a lot of things in addition, and especially with recent tax changes and a lot of different social media accounts that come up. We have a whole process called What Matters Most as well that has a binder for all of our clients that talks about where everything is, so that you can actually track it for all of your family. And some of these things are something that you should always have on hand, because of course, I think initially the checklist kind of just goes through a process of how to actually do it, but some people actually have a whole plan already set out of our client base of what to do. And of course, as you can kind of see, there's a million items on that. This is just a snapshot of the first beginning part of the page. So, I think your first part is obviously getting the funeral arrangement done. And of course, we'll talk in a later session about some of the actual tasks that we do, what's important with how you hold your accounts, how you have designations on some of your accounts, or even your RESP if you hold an RESP for grandchildren. It's like, make sure that that's in your will, because it doesn't necessarily go to your grandchildren if you don't specifically state in your will some of the special wording that these plans need to make that happen. I know life insurance tends to be one of your top ones that you get a check within 3 to 5 days. So if you're looking for speed to get money to the estate, that's probably the best way, because if you don't have joint accounts like Matt talked about with spouses and accounts rolling over quite quickly, there could be a cash crunch. And of course, with the cash crunch, banks will, oftentimes we found that, some of the banks know about these deaths long before the people call them and start saying, oh, I just wanted to notify you of a death. Sometimes they've already known and noted the account. And I know when I worked at TD actually has a special, all banks do, has a special estate department where they actually go through the obituaries every day. And they often will flag all the accounts that they have and lock them down until they've gotten proper notification and proper wills sent to them, and probate even for a lot of assets that are like securities and mortgages. So it's really important to know what all of that looks like and where you're going with it, so that we're able to help you make arrangements. Oftentimes people come into our office, we'll help you walk through this process. Jeff numerous times has sat in the boardroom with some of our clients and even just called bills, because I think, that's important in switching things over. And we talk later again too about how to have those bills properly structured so that you're not going to have a problem later or have reset up charges. So I think all of those things are super important with this checklist, and that's what we try to go through as advisors. And then we work closely with Matt to kind of say, okay, this is where we're going, this is the accounts, and then Matt starts working on probate and starts working on a list of assets, and that ends up being called a NC7 that goes to the courts to properly document all of this. So this is why you want a good plan, but it's not just the will, power of attorney, and personal directives. As you're seeing, there's a lot of activities that actually you just need that document to make all these activities happen with estate planning. Awesome.
Okay, everyone, it's time for some Q&A. So it's Jeff from the Tower Group. Our first question comes from Naomi. She's asking, what are the pros and cons of appointing a lawyer or accountant as your executor versus a friend or family member? What if they retire or close their office?
Excellent question.
No, it's a very good question. So the positive to appointing a lawyer or an accountant as your executor is that they, in most cases, assuming this is a tax lawyer or an estate lawyer or a tax accountant, is that they have the experience and knowledge and understand your estate. In many cases, these are people who have already acted for you during your life, so they understand you, they understand your family. Historically, sometimes these people have been your trusted advisor for a long time, so that makes them very useful. Lawyers and accountants as professionals would have an enhanced duty of care. Because they know more, they're expected to know more. So there's an advantage to having them there as well. They would have connections in the community, so they would know the good financial advisors like Tower. They would know good accountants for other areas if they were an accountant by trade themselves. They would know good valuators in town, so they would be able to streamline, shortcut some methods a little bit because of their industry knowledge. What's the downside to appointing a lawyer or an accountant? Well, they're going to be a little bit more expensive than a non-lawyer accountant. In many cases, they'll either charge their fees at an hourly rate for their time as acting as executor. They'll seek a percentage of the estate similar to how a trust company would. And they'll also seek to be able to use their own firms to be able to handle the legal or accounting. That can be a pro or a con depending how you look at it, but it's pretty standard. Trust companies are the same way. They'll seek to be able to use their investment wing and their private banking wing to be able to work with them as well, both to streamline and both because they're running a business. That's not really a good thing or a bad thing. It's just a thing to be aware of. So I should probably point out as well that executors in Alberta have a right to seek a percentage of the estate. The court have held that to be between 1% and 5%. Trust companies tend to start at about 4.5% and work their way down to close to 1%, depending on the size of the estate. Courts have held that a professional or a non-professional executor who's done a competent job can be somewhere in the midway, 0.15, and an incompetent one who's been removed but wasn't removed because of fraud or malice can still be entitled to around 1%. So that's something to bear in mind. The con is the second part of your question as well, which is lawyers and accountants do retire, they do get sick, they do die themselves. So there isn't certainty necessarily that your lawyer, your accountant is going to be able to act at the end of the day. Unlike a trust company, you can't appoint Field to be your executor. You would have to appoint a partner of a specific lawyer, and then that can be dependent. And even when you appoint a partner of Field, what you're doing is you're appointing a person to appoint executors. So will you get your lawyer that you've worked with for 25 years? Maybe, maybe not. You might get you might get that partner because they want the fees. You might get a junior lawyer. It's a crapshoot at that point, but that may be better than the other alternatives. The other real drawback to appointing a lawyer or accountant is a lot of us won't take these appointments anymore. So historically, you'd see a lot of lawyers who would take on these appointments. Well, the problem is a lot of them have been sued, or a lot of them have gotten involved in files that they shouldn't have. And so as a profession, you're seeing less and less of lawyers doing that. There are still lawyers out there that will, but it's important to ask to lawyers and accountants, especially ones who, like me, act more as an advisor and see the benefit of being the advisor because you acted for the client for a long period of time, and now your family's coming to you to do the legal work because you advised mom and dad. So now you're going to advise the kids. So you can't advise and be the executor at the same time. And so sometimes there's a loss in that. So it's important that if you are going to seek to appoint a lawyer or an accountant, ask them first, and you may come up with a different answer than you thought.
And that's really why the Tower Group really can't be, we get asked a lot if we can be executors on people's estates, and that's something definitely that we can't do because it's a conflict of interest for us to also settle your money and look after your money and appoint people like Matt to help us while we're being a certified executor advisor to the executor. It would certainly be a conflict of interest for us. And I think another thing that I've seen that, is something that people really should consider is, accountants and lawyers go by the book. And you tend to see that, they follow a process and they get the process done. And that's kind of a goal where some of the families have found that, they're really seeking solace and love and hugs and needs. And, one accountant just settled in the state, and the biggest thing that became the problem in the end is he was like, well, the pets are in the house and they had a dog, and he was like, oh, someone will look after the dog and feed the dog, and the dog needed to go out of country, and it was like the last thing on the list, whereas for the family it was probably the first thing on the list and was like that person's child. So that's where sometimes the money and everything else gets shoveled to the beginning instead of maybe that animal that should have been looked after. And it was like, we almost had to interfere because you're getting, comments from people, and people are like, but what about the dog? And I'm like, yes, the dog's important. I'll try to get involved in that because they called me because I happen to know the accountant and knew the family. So, that sometimes what happens is, they're not thinking about the feeling aspect of it. They just try to get it done.
No, that's a good point. And lawyers, trust companies, accountants, I probably say if we want to put them in order on how much they're going to go by the book, accountants would be somewhere in the middle. Trust companies would be the most by the book because they have to report to an executive group. And lawyers would probably be the most flexible, but even then your mileage is going to vary an awful lot. If this is a lawyer who worked with you for their entire career and understands you inside and out, they may be more willing, or they may be even less willing because they've worked with you for 25 years and they understand the situation and they know that there's an element of risk. They may be more by the book. So that's something to bear in mind on that. And I mean, you would have seen more lawyers in the past more willing to go bending the rules a little bit, but that's also why there's been a lot of estate litigation in the last 25 years.
Thanks, Matt. Thanks, Pam. Our next question comes from Nancy. She asks, is it common now to provide compensation and state this in your will for your designated executor? What about the power of attorney? Should the designated caregiver be allotted some compensation from your account while you are alive but incapacitated and they are looking after all your needs?
Oh, that's a good question, and it segues really good from the prior question. So, if you were appointing a professional, you absolutely would have some sort of fee compensation agreement provision in the will or in the enduring power of attorney, or both, depending on who's being appointed. A trust company would insist on having their fees negotiated in advance, though it doesn't always happen that way. And a lawyer and accountant would also prefer, if they're going to be appointed, to have specific documentation outlining how they can charge their fees to avoid issues later, and just to provide certainty. So if the professionals are doing it, why wouldn't everybody? And so there's a couple good reasons for why not everybody would. Number one, a lot of times when people appoint family members, they're also the beneficiaries of the estate. So if we have a situation where a child's getting the majority of the estate and they're also the executor, why would we specifically put in the will that they're entitled to X for acting as executor when that money would be considered taxable income for them when they otherwise would have received a benefit from the estate, which would have been tax-free to them. So that's something that needs to be considered. And an executor has this entitlement to seek compensation. And it's been recognized that it's 1% to 5%. So if we have a situation where you want to cap that, you may prevent an executor or attorney from wanting to act for you because they know how much work it's going to be, they know how much time it's going to take, and they either don't want to do it for $1,000, or they don't want to accept and then have to go to the court and explain why they should be getting substantially more because they don't want to incur the wrath of other family members, or they feel guilted into it. So our general recommendation is to follow essentially what's in the terms of the surrogate rules and in the Trustee Act, and to say that they're entitled to reasonable compensation. What's reasonable compensation? A very nebulous definition by both acts because of that need to have to deal with every situation a bit differently. What are some of the factors? The amount of work that's needed, the complexity of the estate, the acumen of the appointee, and these are things that have to be considered in each and every instance. So I tend to recommend against setting a specific amount of money to act as an executor, but that's not to say you couldn't in certain circumstances.
Thanks, Matt.
And actually for that second part of the question, I realized as I was finishing, I missed the second part with caregivers. So technically speaking, under the Personal Directives Act, you wouldn't put compensation on a caregiver, but that's not to say that they couldn't be given some sort of benefit. They're almost always entitled to reimbursement of their expenses, but there's the consideration that somebody who's acting benevolently for personal matters and making medical decisions and social decisions maybe shouldn't be doing that on an hourly rate. So that's something that in most cases you would see reimbursement of expenses only, but there certainly could be room to make sure that they receive something as well.
And some people, I think, who, I've seen where some families are executors and they're like, I'm not going to take anything from the estate. And I think that's fine too, if that's what they decide.
Great. Thanks, everyone. Our next question comes from Jay. He asks, how much should we set aside to cover accounting fees, legal fees? How do we do this so the executor has fast access to the monies?
So that's a good question. And I'm going to just say that there is no precise amount. There's no hard and fast rule here to say, put $25,000 in an account with somebody else's name on it, because that could be an extremely bad idea. What I can do is give you a general idea on the current costs of what things are, because when an estate falls in, we don't know how much things will cost. To give you an idea, Some of my mentors in the 1980s, when they were doing trust deeds, would charge $60,000 in 1980s currency. Nowadays, we do them for about a tenth of that. So would I say put the equivalent of $65,000 aside to a professional or for an administration now? No, but some of the major costs that come in administration of an estate are your application for your grant of probate. And that tends to depend on the complexity as well, but typically they're within $3,000 to $7,000 to do. Historically, again, we used to do it completely differently, and we would charge what we call the tariff, which is based on a percentage of the value of the estate. And so you can imagine how out of hand large estates would get on their legal fees. Tax returns for an estate, you're looking at least a couple T1 returns. So you'd have your terminal return and a rights and things return in most cases, plus a T3 trust and estate return for every year that the estate or testamentary trusts are in existence. And a good rule of thumb on tax returns, and your mileage with accountants may vary, is expect somewhere between $1,000 to $2,000 per return for these types of returns, because they're a bit more complicated than just spitting out T4 information into a personal return that H&R Block can do. There may be some real thinking and real tinkering involved to make sure that the information is properly communicated to the tax authorities and to make sure that things are done properly the first time. In some cases, there may be need for taxpayer relief applications, clearance certificates, tax litigation. There may be civil litigation. So it's tough to say for certain to leave a certain amount out. Now, that being said, one thing to watch are tax deferred assets, so things like RSPs or RIFs, because they carry the tax burden to the estate, whether or not the money stays in the estate, unless it's subject to a spousal rollover or something of that nature. So you would want to make sure, and having good financial advisors, you would have a certain amount of your portfolio in cash, and there would be certain assets that are. And I think that would be the best advice to have is if there's cash on hand that's available. In most cases, when you're dealing with a bank in the States, if there are existing expenses, they can be deducted from the account. You just can't take money out willy-nilly, but you can usually have pre-existing expenses taken out. When it comes to law firms and accounting firms, for the most part, for applications for estate administration, we don't issue an account until we've gotten the grant, because we know that you can't get the money out in many cases to pay us until then. So there's a fair amount of flexibility in estate administration where there's a will. Where there isn't, we can run into a bit more problems because there's an issue of being able to verify that you're the person entitled. But there's ways around that too. I've had estates where we've just gone and got a court order. So an insurance company would be able to do something for the future administrator of the estate. So yeah, your mileage will vary. So it's something to kind of speak with your financial advisor and make sure that your portfolio is properly balanced so that there's cash on hand and no tax surprises if something happened to you.
Exactly. Thanks, Matt.
Our next question comes from Bill. He's asking, what if I am executor for someone who has property outside of Canada? Or if my executor or guardian lives in the US, would that create major complexities? Or how can we keep it simpler?
So good question. So I'm going to kind of split my answer up into the two different parts here. For the first part on a Canadian holding assets in multiple jurisdictions, yes, you're going to have a complex estate. There's just no two ways about it. Can it be made simplified? A little bit, but we're still dealing with the laws of multiple jurisdictions. So Alberta has different rules than every other province, let alone states and countries. There's a general understanding with multiple countries that have signed a convention on the form of international wills that they'll recognize the form of a will and its validity. Now, does it recognize all the nuances of each jurisdiction? Is it tax advantageous? Maybe not. So in a lot of cases, you'll see multiple wills. You may have a will for Canadian assets, a will for American assets. The Canadian and American ones can often play together well. So you may have other structures like trust. You may have other entities that would be administered differently holding it. So you may have a corporation owning interests in something. I mean, again, be careful with that because there could be shareholder benefit. But long story short, you'll want to get advice in every jurisdiction you hold property in to make sure.
Oh, and it looks like Matt's frozen up a little bit here again. Sorry about that, everybody. But yes, you have to have
sure that you're doing it properly. So, for example, in the state of Florida, an executor has to be. Oh, I'll try repeating that one again. See if I come through again. So, in the state of Florida, for example, we get the marvels of technology. So in the state of Florida, an executor can be a state resident or a blood relative only. So if you have, for example, a trust company or a lawyer appointed for your Alberta estate, and it makes sense for Alberta, it may not make sense in Florida. So it's important, and other US states that may have other rules like that. So it's important to get advice on both sides of the border and in other countries as well. For a foreign personal representative for an Alberta estate, that's a lot more straightforward in most cases, but you'll want to be really careful if there's going to be trusts arising out of it. So provided that an executor is able to get their bond posted or have that requirement dispensed from, it's considered an Alberta estate, even if that person is not resident in Alberta. So they'll be able to administer your Canadian assets without any real problem. Now, it becomes a problem if there's a trust that arises, because now we're getting into trust law, tax law, and you may have a situation where more tax is payable than it should be, that things have to be dealt with in a different way. There's ownership of property issues that could arise. So you'll want to be careful on that. And that's one of those things in each instance you'll want to review carefully.
Exactly, especially those that have a Palm Springs and Arizona property. You know, I know a lot of Albertans all do. So, or even, you know, a lot of people are buying in BC for, you know, Victoria or the interior BC, and that's all different jurisdiction as well.
That's great.
Yeah, and in particular with Alberta and BC, you'll want to watch that one because it seems like there wouldn't be a whole lot of differences, but there's a very different tax regime when it comes to probating of estates. And you'll want to be careful how your property is held because you may have a substantial amount of tax payable in BC.
Awesome, thanks. Next question comes from Veronica. Can an executor be sued? And if so, do they need special coverage?
So anybody can be sued by anybody if they've got a couple $100 burning in a hole in their pocket. So I couldn't tell you with a straight face that an executor or trustee couldn't be sued. Now, are they going to be personally liable? Not necessarily. In most cases where there's a state liability and the state's being sued, the executor personally is not liable. They're acting as a representative of that entity. And in many cases, even if an executor is named and they haven't acted in bad faith, the estate would indemnify them to the extent of their assets. Should they have insurance? We recommend it be considered every single time. It's in my engagement letter for estate administration, and it's something that executors and trustees can consider. But I would recommend, if you do that, to review the policy carefully and make sure that it actually covers errors and omissions and doesn't have a bunch of carve-outs that defeat the purpose.
Thanks, Matt. So our last question comes from Gabe. He's asking, can you be named executor without knowing?
Definitely.
Absolutely, you can. Does it mean you have to act? Absolutely not. So I've had more than a few cases where a client has come to me saying, I've been appointed on this god-awful will and I don't want to act. What do I do? And the answer is you renounce. And the important thing is, if you're not going to want to act, to know that relatively early in the process, because if you do too many things, if you've been seen to put forward the estate other than ascertaining assets, protecting assets, and making initial inquiries, you may be seen to intermeddle in the estate. And if that happens, you may have some personal liability unless you're discharged by the court. But in any case, your ability to act materializes from the will, but you're not necessarily forced to act until you have accepted it. It's essentially like a contract where there's an offer and an acceptance, and you're not on the hook until you decide to be on the hook. But once you're in, you're mostly in without the court's approval to remove you later. And this is why it's very important to talk to your appointees, your executors, agents, and attorneys in advance so that you can avoid this situation as best as one can. I mean, there's always going to be situations where somebody agrees to be appointed, wants to act if they have to, and then life happens to them too. And maybe they've been diagnosed with an illness, or they went through a particularly ugly estate and they don't want to do it again, or any other reasons like that. So communication is key, and that's also why it's important to review these documents on a fairly consistent basis. Does that mean you have to make an appointment with me every 6 months like a dentist for a checkup? No. I don't think that's necessarily cost effective or time effective for anybody. What it means is every so often, whether it's every year or every 6 months, you look at your documents yourself, you give them a quick read. Do you still like the people you're appointing? Do you still like how the estate is being distributed? If the answer is yes, put it away for a little while longer. Talk to Pam when you're doing your financial review, and she may be able to let you know if there's been changes in legislation that may be worth having a conversation with me or with your accountant or with another lawyer. And that's kind of the general rule. I'd say every few years, anytime your life changes, you'll want to come back in front of a lawyer and maybe make changes or maybe not make changes. But a good reason to do that is to prevent the situation of somebody being appointed who shouldn't be or doesn't want to be.
Awesome. Well, thanks a lot, Matt. Those were some great questions. We really appreciate the answers as well. Pam, I'll leave it off to you for any closing comments to finish off the webinar.
Great. Thanks so much. Thanks. I do agree. Those were awesome questions. So thanks very much, everybody, for submitting those questions. And thanks for attending today. And thanks for your great advice, Matt. And we always appreciate having you here on all of our sessions. I think everyone really enjoys it. We've had a lot of great comments so far, so we appreciate it. Thanks so much.
Hey, thanks for having me. It's been great.
And everybody, just to let you know, on Tuesday, we gave it a survey, and it sounds like everybody's kind of chomping at the bit to get a new market update on what's happening and what's happened over this COVID last 3 weeks of our lives that have completely changed. So Tuesday at noon, we're going to have a COVID market update, and then on Thursday, we're bringing back Matt again. And we'll have a discussion on, what lawyers do and what certified executors do and how we work together during that session. So we look forward to having you guys all back, and we look forward to having you back as well, Matt. Thanks so much.
Thank you.
Thanks, everybody.